Hello everyone. I'm hoping that all of you are watching the video are safe at your home, and I'm reiterating that please stay at your home. Do so many positive things, focus on your hobbies and spend time with your loved ones, but please don't step out. I know that we are going through a terrible situation, but with positivity, with love and care, I think we will come out of this very soon. And as I had told you that I would take some lectures on basics of international tax and then progressing towards some important issues which I could touch upon. I'm not targeting very large videos. What I'm trying to focus on is 30, 35, 45 minutes video so that you can also watch it in your spare time and it's not too long for you, because I know that in work from home it's very difficult for you to also focus specifically on videos, but still many of you are taking out time, so then I'm keeping it really very short. And so beginning with it today, I'll discuss some of like very basics of international taxation, because what happens is that we know many of the things which exist, but we don't understand why things exist. And there are so many things available on really high-ended things, but very few things on basics. So I thought let's try out with the basics to start with the basics. So let's begin with it. International taxation. What is particularly international taxation? So international tax comes into play, when there are two countries' laws involved, and when two countries are trying to tax a same person or maybe different person having the same source of income. So that's when two countries try to assert their jurisdiction over the same subject, and that's when international tax comes into play. So now how is it very different from our domestic tax laws? Because in domestic tax laws, the subject is within the same tax jurisdiction and we are applying that particular law. There is the same judiciary, our own domestic judiciary, where we can litigate our matters in case of in discrepancy between the taxpayer and the tax authorities. But under international taxation, what happens is that we have two countries operating over the same subject. It could be the same income, it could be the same person, and in that particular case, we have to now resolve the double taxation that would happen because of two jurisdictions asserting their taxation right. To avoid that double taxation, there have been double tax avoidance agreements in place. So now these double tax avoidance agreements are public international law. With this, they are there for many other objectives as well, but one of the principal objective is to avoid double taxation. So that's where international tax comes into play. So it's like domestic tax law of one country, domestic tax law of another country, and then there is a subset in between, which is double tax avoidance agreement. Okay, so now double tax avoidance agreements are public international law because they are the kind of contract, kind of agreements entered into between government of two contracting states. Two contracting states as in two countries. So in international tax terminology, they use contracting states. That's how you would have read into your DTAAs as well. And the disputes which are concerned with double tax avoidance agreements are basically to be placed before International Court of Justice if both the countries agree to it. Otherwise, how do they resolve it? They resolve it through mutual agreement procedures. Mutual agreement procedures are something where the competent authorities, designated competent authorities of the two states, come together, they resolve that issue. They come forward to resolve the issues concerning interpretation of double taxation avoidance agreement, because your country's judiciary, your country's court would definitely resolve the case, but that would be that country's position. That would not alter what other country's court may take the position. So there would not be any same position adopted on a DTAA level. So say for example, India may say this is royalty. However, Australia may say this is business income. Both courts can rule separately. Therefore, there is kind of a need to resolve the disputes under mutual agreement procedure to bring the settlement, but it's a very long time consuming process. But that's how the disputes are dealt with under international taxation. Now, what are the objectives which it tries to achieve? It kind of tries to promote the fairness, because what happens is ideally both the countries are trying to tax same subject or same income. So there would be ideally double taxation. So if I would have invested in my country and not in some other country, I would have been taxed at a very lesser level. Compared to when I'm investing in other country, there is additional taxation by that country as well. So to promote the fairness between two kind of taxpayers who are investing in my country and who are investing in another jurisdiction, so that there would not be any additional tax burden on them, and to also promote the trade which is happening or the investments which are getting done to another country. So those objectives are tried to be achieved by double taxation avoidance agreement. Now, there are model tax conventions which are in place. You would have heard about OECD model, UN model. What are these? These are basically the formats. So when two countries try to enter into agreement for double taxation avoidance, that time they start with a model treaty. So those models are basically OECD, UN or US. OECD model is majorly based on residence principle because it is done by developed economy. It is made by developed countries. UN model is by developed and developing country. So there are some rights given to the source jurisdiction, because ideally the source jurisdiction are most probably they're not developing countries because they are capital importers. So they wanted the taxing rights which are found under UN model. So many of the developing and developed countries double tax avoidance agreements which are there are based on UN model. US has its separate model. Then also you would have heard something about Vienna Convention on Law of Treaties. What is VCLT, Vienna Convention on Law of Treaties? It's basically a customary law which is for interpretation of treaties. I'll try to take a separate lecture on it, but just for now, bringing you some new concepts which you would have heard but may not have known the meaning of it. So VCLT is basically customary international law. It is developed through the interpretation principles used customarily, and it is kind of used for interpretation of treaties. For now, just remember this, and then we would look upon it like what kind of principles of interpretation are in that. So just to give you an example, maybe principle of good faith, that the treaties shall be interpreted in good faith. There are many other principles in Vienna Convention on Law of Treaties. Now, coming to double taxation avoidance agreement, how the relationship functions between the domestic tax law of a jurisdiction and the double tax avoidance agreement. So there are two kind of ideologies which exist. Different countries follow different ideologies. The two views are monism and dualism. What is monism? It is like the international tax treaty is a part of domestic law. It is considered as a part of domestic law. It's not considered something separate. Dualism is that it needs to be expressly incorporated into domestic law. Unless and until you ratify it into your domestic law, you incorporate it into your domestic law, it is not considered as part of your domestic law. What does Indian Constitution says? So Indian Constitution under Article 253 authorizes Parliament to enter into implementation of treaties. There is also Article 73 which gives the power to the executive. So under Indian Income Tax Act, under Section 90, the central government is authorized to enter into double tax avoidance agreement. Okay, but it requires implementation into domestic legislation, which is through Section 90. So what does section 90 says? That DTAA or act, whichever is more beneficial, will prevail. There was one circular also which said that specific provisions of DTAA will prevail over the general provisions of the act. Also, we would try to get into treaty override and all in the subsequent lectures which I may take up. So, but this is how the Indian Constitution functions. Now, what is the structure of DTAA? The structure of DTAA is like the initial articles define the scope of DTAA, like who can claim the benefits of DTAA. So the initial scope, what does DTAA caters to? So the preamble, article 1 about the persons covered, taxes covered, which kind of taxes the DTAA caters to is under article 2. Then comes definition, the terms which may be expressly defined under DTAA. Then comes the residence principle under DTAA. Like who is resident? That is specifically defined under DTAA. Then Article 5 is there, which is definition of again permanent establishment. And then Article 6 onwards to Article 21, 22, there are distributive rules. What are distributive rules now? So DTAAs, what do they exactly do is, they try to distribute the taxing rights between the source and the resident country so that there would not be any double taxation remaining, or the double taxation is mitigated or avoided. How does it do? It distributes the taxing right between the two jurisdictions. So now, as per a interpretative principle, or as per one of the principle, is that a resident country always has the taxing right. So some of the authors view this, that a resident country always has a right to tax its subject. Now, what remains is the source country's right, which is altered by DTAA. It's not completely altered, it's restricted, I would say. Altered would be a wrong terminology to use. It would be restricted. So now to briefly describe about it, that how do we tax a subject? Why a subject is being taxed doubly? A person or income. That is due to the reason because an income may arise in, say, source country, which is, say, India, by a resident of Australia. So Australia derives nexus through residence principle. Because that particular individual is a resident of Australia, that income is being taxed in Australia. Similarly, that income is accruing or arising in India, because that say income is rental income. Property is located in India. So by virtue of the source principle, by virtue of accruing or arising of income in India, India becomes source country and it tries to tax by virtue of source principle. That's how double taxation is happening. Therefore, what DTAA does is, it distributes the taxing right between two countries. So resident country will always have primary right to tax its subject. Who has a secondary right? The source country. Okay. So for a resident country, global income of its resident is taxable in that particular country. So DTAA will restrict the taxing right of source country by either giving it limited right or giving it a full right to tax. In that case, the resident country may have to exempt it or give the credit of taxes in source. Or it may give a conditional right. So these are the kind of distributive rules which exist. A complete distributive rule, which may say that entire right to tax is with the source country. This could happen for immovable property, for capital gain, or it may give a conditional right. Conditional right is like, if you fulfill certain condition, then the income will be taxable in source country. Example could be business profits. Only if a P exists in source country, the business profits will be taxable in source country. So that's a conditional distributive rule. And then there is limited distributive rule. Like for example, under dividend, interest, royalties, fees for technical services, that a limited portion of withholding tax a source country can levy. 10%, 15%, depending on the negotiation power of two countries. So that's how the distributive rules function. Then, whatever the taxes are paid in source country, the resident country is obliged to grant the relief if the source country has taxed that particular income in accordance with DTAA, in accordance with the rules and interpretation of DTAA. Resident country will either exempt if it follows exemption method, or it will grant credit of taxes paid in source country. Then that's a double tax relief. Then there are some anti-avoidance rules in the double tax avoidance agreement. Say for example, limitation of benefits clause. And then there are administrative provisions like exchange of information, mutual agreement procedure. So that's how a normal DTAA is structurized. So as I said, how the nexus is obtained, source and residence. Residence is very well defined under DTAA. Though it makes a reference to domestic law, which we will see when I will try to cover Article 4. Source is not particularly defined. What is source? Where the income is accruing or arising, that's left to domestic tax law. It is not defined under DTAA, but it is as per Income Tax Act. So this I covered function of DTAAs. Then what could be the conflict of laws which DTAA caters to? For example, resident source, the first example which I gave you was resident country is taxing on residence principle, and then the source country on source basis. There could also be residence conflict. This may be a clear-cut example would be I am a resident of India because I am a company which is incorporated in India. At the same time, I have place of effective management is say Singapore, and Singapore taxes a company based on place of effective management. So there is residence conflict, because of which DTAA will try to resolve that through tiebreaker rules, which we can see it later. Then there could be source conflict, where a payment is made from one source, payment is made by one country, and the other country also considers it that it is paid by them. That's very technical and which I'll not get into at present. Income characterization. Say for example, I may characterize it as royalty. Other country may characterize it as business profit. Then entity conflicts. In case of fiscally transparent entities, one country may characterize it as partnership, other country may characterize it as body corporate. Or one country would say it's a transparent, other would say it's opaque. Timing differences, one country may tax it when the profits accrue, the other on receipt or when the profits are distributed. So these are the kind of conflicts which occur under DTAA. DTAA doesn't solve all of this. It solves majorly residence and source principle. But through interpretation, through various kind of relief articles present in many of the DTAAs, other conflicts also could be solved to certain extent, but not completely. But DTAA majorly caters to residence source conflict and not other kind of conflicts which exist. So there would be ideally double tax, which will remain despite having DTAA. Double tax relief, I explained credit method, exemption method. Now credit method is basically based on concept of capital export neutrality. What is capital export neutrality and what is capital import neutrality? So capital export neutrality basically concerns with that if I invest in home country, as I said, or if I invest abroad, the tax burden on the investor should be same, which can be relieved through credit method. Exemption method caters to capital import neutrality. So it says non-residents investing in a source country So it looks upon the source country basically. So if you invest in a source country, the non-residents which are coming in your source country should bear the same burden as your resident investors. So it could be resolved by exempting in their resident country the income itself. But under credit method, losses are allowed to be set off. In exemption, if the income itself is exempt, the losses are generally ignored. So this is how the DTAAs function basically. And in this particular session which I have recorded, I'm restricting it myself to this particular structure and the scope which is there. You could leave the comments what else you want me to cover in this. I would try to cover more lectures on it, but of course I would be covering additional lectures again. But if in this particular thing, if you have something, I could also cover more about it in detail. So you could always leave it in the comments, whatever you have the feedback about it. That's it. Thank you. And please stay safe and please stay indoors. Thank you.